wonderful, beautiful place to have this conference. We're very excited to be here. As our regulars know, we have been partnering with Eric Chafee, who's in this room somewhere. There he is, on this conference for many, many years. And recently, Eric transferred over to Case Western, and that is why we're fortunate enough to be able to partner with this fabulous law school. Thank you, Eric, for continuing the partnership and making this great event possible. I also want to thank Patty Arbold. I don't know if she's back here, but she also is instrumental to the success of this event, allowing us this great space, also allowing us to do it hybrid. So welcome this morning to our virtual attendees as well. I know that she's put a lot of work into this, and I really appreciate that. We have some law students. I think most of them are attending virtually this year, but one of the things we started doing a few years ago was opening an invite to every one of the Ohio law schools and funding registration for at least one student, because we're really trying to get the new legal minds exposed to the securities market. And certainly people are taking advantage of that. So good morning and welcome to the next generation of securities lawyers here in Ohio. So if there are any students in the room, I think there may be a few, I wanted to introduce some of the staff that is at the Ohio Division of Securities, so that you should take some time today to say hello to them. It's a good time to make. It looks like we're sticking together over here. But John Christ is our compliance director. Janice Hitzeman is our enforcement chief. David Beamel is our deputy attorney inspector. Jeff Coleman is one of our senior compliance attorneys. Amazing talent. Chris Ballard here in the center. He's the one that keeps us on time today as another senior enforcement attorney. We also have Chad Kohler from the Attorney General's office here somewhere in the back. He represents us in administrative cases as another person. If you're interested in the administrative side of the law, you can reach out to any of these people and learn more about what it is. So I'm just gonna go over some housekeeping items for all of you. First of all, we want your feedback. We know how we're doing today so that we can improve the program next year. You guys know with our first year doing this at Case, we're learning some things. People are asking about parking and all these things. So please let us know what we can do to make this experience more seamless and more enjoyable for all of you. So do fill out the survey. It only takes a few minutes. And again, we're really asking these questions so we can improve the experience for all of you. If you're an attorney or a CFP who wants continuing education credit, you do need to sign up on the registration desk outside. You will also have to fill out a short form online after the event, confirming your attendance and letting us know how many hours you need to claim. We do the submission for you. You just need to make sure you fill out the forms that we provide, and we will take care of those submissions for you. If you have any questions on that, Ray Lynn, my assistant, is one of the people that is out there at the registration desk. I couldn't do my job without Ray. Anybody who works with the Division of Securities know how important he is, but he will make sure that you get your credit. So if you do have any questions on that, please do not hesitate to reach out to Ray Lynn. I'm going to ask everybody to silence their cell phones, laptops, smartwatches, etc., so that we aren't distracting or disrupting any of the sessions today. We're going to have 15-minute breaks between sessions and then a 30-minute lunch. If you didn't notice, there is coffee and pastries and some breakfast items behind the room, so please enjoy those and take care of those. And then we will have a 30-minute lunch. But we like everybody to be back in their seats when the breaks are over. So please try to cooperate with that. Lastly, if time allows, our panelists and speakers will take questions, usually at the end of each presentation. If you're attending virtually, please submit your questions via the chat feature on your Zoom screen. And if you're here in person, just the old-fashioned way, raise your hand. Do not be shy. If we have chance opportunities for questions, I like interactive conversation dialogue. I would encourage you all to do that. May not be able to get to all of your questions, which typically happens as well, but we'll do our best to answer as many as we can. I think that's all I have in terms of housekeeping, but if any of you have any questions for me, please feel free to reach out to me during a break or call, email me. I try to be pretty accessible to everybody. I know a lot of the faces in this room, but I'm really happy to have you all here. And with that, it's my distinct pleasure to introduce the new Dean of Case Western Reserve University School of Law, Professor Dean Paul Rose. So please. We're excited to have you. Thank you for partnering.
Thank you. Well, I really am thrilled to welcome you all here. This is a conference that I have attended a number of times and spoken at a number of times. I've been a professor of securities regulation for 20 years now. This is my 20th year. And so I'm especially excited to have this conference here at Case. I know that this conference comes together through the work of a lot of folks. And I really want to spend just a couple minutes thanking Professor Chafee and the commissioner and David for their hard work in putting this together. It's a fantastic program. I have to confess that for years I had hoped to pry this conference away from Eric when I was at Ohio State. I really did. But of course, I was never able to. And so this truly is a case of where if you can't beat them, join them. So this is a really, I think we say this a lot, but this is really a moment of a lot of regulatory change in securities law. And I just want to touch on just a few of these key developments. We're going to be speaking about many of these today, from debates around corporate disclosure to cryptocurrencies to the major cases that are going before the Supreme Court. One of the top regulatory priorities this year has been enhancing environmental, social, and governance disclosures, and the SEC's trying to standardize ESG reporting, particularly regarding climate-related risks. And their aim is to provide investors with consistent and comparable information. And of course, there's a lot of controversy surrounding those proposals, especially over the burden, perceived burden on companies, the question surrounding what would be considered material. And of course, these debates are going to continue. And I think that practices are evolving, maybe alongside of that, and practice is going to evolve in a way that may or may not be consistent even with what the regulation is trying to do. The regulation of cryptocurrencies and digital assets, of course, remains a crucial issue. There's been a lot of enforcement activity by the SEC and, of course, state regulators, with the continued goal of determining where that line is between something that really should be considered a security and other kinds of instruments that really are not securities, that really function more like a classic instrument of money. And I think that the industry has really been effective in pushing back. At least they've spent a lot of effort in pushing back, arguing for clear regulatory guidelines. As digital assets become more integrated into the financial system over time, of course, this tug of war between innovation and investor protection will shape SEC and state regulatory enforcement activities, and of course, potential legislative reforms. The expansion of private markets has been going on for quite a while, and of course, some of that has been aided really by things like the Jobs Act that's made it easier to stay private longer. There is growing concern, of course, about the divide between accredited retail investors, and policymakers are continuing to ask whether greater access should be provided to those kinds of private market opportunities to a broader range of investors. What kind of safeguards should be put in place? Enforcement, of course, has been a critical part of maintaining market integrity, and of course, this year has been no different. The SEC's continue to focus a lot of attention on insider trading, market manipulation, misleading disclosures. And another area of focus has been on the role of financial intermediaries, broker-dealers, investment advisors, to ensure fair practices, to avoid conflicts of interest, particularly in the wake of the meme stock phenomenon and increasing market volatility. And I know that Eric and Professor Pritchard, two professors who thought a lot about what the Supreme Court is doing in securities, they're gonna spend some time talking about a couple of cases and maybe a couple more on deck. I'll just maybe preview that really quickly. We've had, of course, 2 pivotal Supreme Court cases this year. I love to see those kinds of cases as a securities professor, just to get clarity where we can. The Macquarie case unanimously held that failing to disclose information required by item 303 of SK cannot sustain a private claim under 10b-5b unless an existing statement is made misleading by that omission. The decision confirms that pure omission claims where a material fact is omitted without an accompanying misleading statement is not actionable under 10b-5. So plaintiffs must demonstrate that the omission made other statements by the defendant misleading. And so that's one major case. And then, of course, the Jargasi case from this summer held that when the SEC seeks civil penalties against a defendant for securities fraud, the 7th Amendment entitles the defendant to a jury trial. The decision limits the types of actions that the SEC can bring through enforcement proceedings and calls into question the ability of other agencies to seek civil penalties through administrative proceedings. So looking ahead, we have NVIDIA and Facebook, which both could significantly impact securities litigation and corporate disclosure standards. They both raise critical questions of the boundaries of corporate liability, standards for investor lawsuits under the PSLRA. In the case of NVIDIA, as you know, the PSLRA was supposed to curb frivolous class action lawsuits and requires plaintiffs to meet a heightened pleading standard, proving that defendants acted with scienter and that their misstatements or omissions were material. So depending on the court's rulings, we can see a shift in what's required for proving that kind of knowledge, for proving what falsity means in that context, potentially making it easier, potentially making it more difficult for investors to bring securities fraud claims. Facebook, it's a case where the Supreme Court is considering what companies must disclose in the risk factors section. I'm chuckling because perhaps only in this group, with this audience, could I admit that my favorite section of Form 10K is the risk factor section. And I suppose it's maybe embarrassing to admit that I actually have a favorite section of Form 10K, but I do. And so these cases this case will be really interesting to help maybe bring some clarity into what needs to be disclosed in the risk factors section. So what's on the horizon? Well, there are several other critical issues on the regulatory agenda in the coming year. Of course, cybersecurity remains a really important issue. New rules are being proposed to enhance cybersecurity risk management and disclosure requirements for public companies. And of course, there are efforts to modernize corporate governance, reforms around shareholder proposals and proxy voting. This is, I don't know if I would call it an area near and dear to my heart, but certainly an area that I've spent a lot of time thinking and writing about, thinking back to the 2020 proxy advisor rules, and then the SEC subsequent reconsideration of those rules when the administration changed. I frankly wonder whether we've entered a regulatory era where, compared to past eras at least, the SEC's priorities tend to shift more dramatically with each new administration that comes in. I don't know if that will be the case, but I think that is something we'll all be watching. So just to conclude, there's a lot going on, of course, in securities regulation, both at the state and federal level, and today's discussion will help us navigate the complex and evolving legal environment. I look forward to hearing from our distinguished speakers and panelists. And again, thanks to the commissioner, thanks to Professor Chafee, thanks to David, and to all those who have really put time in to make this conference possible. And I'm really grateful that you're all joining us here today. So with that, let's get started. Thank you.
Yes. All right, and ladies and gentlemen, because we are doing this as a hybrid event today, we do actually need to stick on the schedule as it is. So we're going to go ahead and have a 10-minute impromptu break. So if you're in the room and need Bobby Phillip, please do so, please be back in your seats at 8:59 for Professor Adler and Enforcement. Thank you. All right, ladies and gentlemen, we're going to go ahead and get started on our next panel. One small correction for our virtual attendees. If you do have questions, there's a Q&A button inside your screen. I apologize for the incorrect information I gave the commissioner this morning on that. So click on Q&A and we will see your questions as they come in. I am pleased to introduce our next panel, Professors Jonathan Adler and Charlie Corsmo, who teach here at Case Western School of Law. They're going to be talking to us about agency deference. For those who aren't aware, there have been some major court opinions that have come out in the last year and a half, perhaps, dealing with this particular issue, which is, of course, very important to the Division of Securities and other regulatory agencies. So, professors.
First, all right. Well, thank you and welcome, all of you that have come from various parts of the state to Case Western. It's great to have you here. I have a confession to make just at the start. I know very little about securities law. And so it's a bit daunting to be in a room full of folks that do securities law at a securities law conference, but I will do my best. What's a little worse is that after this, I have to go to give a different talk about Supreme Court stuff to a bunch of bankruptcy judges. And I never took bankruptcy law, and I'm supposed to talk about the past term of the Supreme Court, which normally wouldn't be a big deal, but this past term, the Supreme Court actually decided an important bankruptcy case, and they might want me to talk about it. So this is the warm-up. What I want to do relatively briefly, and before turning it over to Charlie, and then certainly leaving time for your questions, is just say a little bit about Loper-Bright and what it does and does not do in terms of the way we think about deference to regulatory agencies, and to kind of preview what my bottom line is. I think what's important about Loper-Bright is less the headline, less the tombstone that Justice Gorsuch flagged in his concurrence, but more what's occurring operationally within the opinion, that is to say, what the opinion tells us about what judges are supposed to do. Because it's my contention, 80 to 90% of that opinion would have been consistent with the court saying Chevron is not overturned, but here's what it means now. And then it's also significant in terms of the extent to which it places an exclamation point on some broader trends in the Supreme Court's jurisprudence with regard both to statutory interpretation and how judicial review of agencies is to be conducted. And that to really understand the impact Loper-Bright's going to have for all of us, those are the things we want to focus on. The headline Chevron overturned is really not what's doing the work. So to set this up, let me say a little bit about Chevron's history. This makes me feel more comfortable because I can talk a tiny bit about environmental law, which is where I spend a lot of my time. Chevron, as you may all know, is a case involving Chevron, the oil company, and the application of the Clean Air Act to stationary source emissions. And the big issue in Chevron is what's a source? Because a stationary source needs a permit to do things, to make changes that are going to increase emissions. And so the question was, is a source like a smokestack? Is it a building? Is it a factory? Or in the case of something like Chevron, like, is it the entire operation of, say, a single refinery, which could span acres and would encompass lots of discrete points? And it turns out the Clean Air Act doesn't answer this question. Not only does it not answer this question, it doesn't give any clues. And not only are there no real clues in the act itself, there isn't much in the history of the act, in its legislative history, in other discussions about it. It was just something that in all the detail the act contains, and it contains lots of detail. It's one of my favorite environmental laws. It's lots of fun, but it doesn't answer this, what turns out to be a very important question. And the Reagan administration wanted to change the way the Environmental Protection Agency applied this part of the act to make the law more flexible, make it easier for firms to comply, so that environmental goals could be made at lower cost. The concern from some was that this would reduce the effective environmental stringency of the Clean Air Act, make it easier for oil companies to make operational changes at refineries without having to install additional pollution control equipment that would be required to obtain new permits. And so the case goes up to the Supreme Court over whether the Reagan administration's interpretation is permissible. A really funny thing about this case is it's unanimous. It upholds the Reagan administration. And as we know from the justices' papers, no one on the court thought they were doing anything particularly unusual. They thought this was just statutory interpretation in the context of agency regulation, the way it had been done for the prior 50 years, even preceding enactment of the Administrative Procedure Act. That you look at the statute, you look at what it does, you look at what the text says, you look at other clues to statutory interpretation, you look at what the agency's doing, and you take into account the fact that the agency has some expertise and experience with this statute that the judges don't have, and that Congress maybe have been okay with that, and therefore would want the agency to be able to exercise policy discretion when implementing the act. And the court recognized that the question of what's a source is not a question about what's the semantic meaning of this word. It was a policy question. Do we want to interpret this language in a way that emphasizes reducing pollution at every opportunity, or do we want to interpret it in a way that emphasizes operational flexibility in the context of environmental compliance? And that's a policy question, and a policy question that Congress had not answered. But as it turns out, in writing this opinion, Justice Stevens gave us this paragraph, and it's one of those paragraphs that as a law student we learned to really love, right? Because there'll be this long, sprawling opinion. It'll be about some subject that we might not know much about. This is particularly true in administrative law. And we are searching for that one paragraph that tries to crystallize everything the court is doing into the one thing we can kind of circle, highlight, perhaps commit to memory for the exam, and think that we're good. And Chevron has that paragraph, and it's a beauty, right? Because it says anytime we're confronted with a question of evaluating an agency's statutory interpretation, we do two things. First, we look at the text, and if the text is clear, we follow the text. And then if it's not, we defer to an agency's reasonable interpretation. And again, the court didn't think it was announcing a new test. And if you look at the rest of the opinion is a lot less formalistic than that paragraph seems to be. Right? A lot more, we've got to really look at everything and really be appreciative of the broader context in which the statute was enacted, and it's implemented and enforced and so on and so forth. But that paragraph was there. And it didn't take long for judges on the DC Circuit and for attorneys in the executive branch to seize on that paragraph. And we know the tail end of the Reagan administration and the Bush administration in particular, that paragraph was really seized upon as a way of deflecting judicial review or easing judicial review of agency action and making it easier for administrative agencies to, among other things, change policies and to argue that they could do so within the relevant statutory text. And this test also was, in some respects, easier for judges to apply than the more fulsome context-heavy deep dive that had been the traditional approach that courts had adopted, and that, again, in fact, Stevens had actually done in the Chevron case. And that's probably part of what Chevron's downfall was, right? Because this paragraph gave us a relatively easy test. We look at the statute. If it's unclear, we defer to the agency. We don't even, and key, the opinion said it doesn't even have to be the best interpretation of the statute. It has to be a permissible one, right? So we don't even have to be fully convinced. So think about your favorite really complicated statutory provision or statutory framework, right? However much we might like these statutes, due apologies to the dean, however much we might like specific provisions of particular statutes, we often recognize that a lot of the slog part of unpacking a statutory provision is not always the most fun part. And especially if it's not what you do on a daily basis, right? You're a district court judge, you have some securities case. This is the first securities case involving the SEC you've had in 3 years. You haven't thought about these provisions in a long time. It's really difficult. Some people that know a lot more about this than you do come before you. And you might be inclined to find that statute's ambiguous when it's really just hard. When it's really just kind of poorly written. Not unclear, right? Not that there isn't, in fact, a reading you can wrestle out of it that is clearly better than the rest, but it's just hard. And, the SEC deals with it, and they're kind of telling you, Your Honor, we think it means this, but hey, if you're not convinced it's ambiguous, you have to defer to us. And we know that that's, in fact, what courts did. And we know that long before Loper Bright, long before the current composition of the court, a lot of judges, and justices, including some that at one point had been big fans of Chevron, started to say, hey, wait a second, we're kind of short-handing or we're short-circuiting that initial step of really looking at what Congress did. And we're just kind of using this as a shortcut. And I think it's worth pointing out that this concern was building well before the current court composition. So, for example, one of Justice Kennedy's last opinions as a justice in his last term was a separate concurrence, basically saying we've either got to give lower courts clearer instructions so they actually do the work, or we're going to have to rethink this whole thing, right? And we don't think of Justice Kennedy as a particularly aggressive anti-administrativist justice, right? So this was a fairly broad concern that courts were not doing the hard work of really figuring out what statutes mean. Other thing that was occurring over this period is the Supreme Court and lower federal courts, as a consequence, were becoming more textualist in their approach to statutory interpretation. Right? So if you look at Justice Stevens' opinion in Chevron, he's looking at everything. He has this whole long discussion of legislative history. The lower court opinion, which kind of interestingly enough had been written by then Judge Ruth Bader Ginsburg, did the same, right? Looked at everything. Well, these days, that's not necessarily what the court does. There are a lot of justices that think that legislative history is too easy to gain, too easy to manipulate, is not as important as looking at the text itself. And so there is a much greater emphasis on text first. And I think that accentuated the concern or the disquiet that the Supreme Court in particular had about the way lower courts were applying Chevron, because they were not only kind of saying, gosh, this is hard, we don't know, we'll defer to the agency, or as one of the lower courts did in the Loper Bright case, and in the companion case, Relentless, which by the way, imagine how much fun it would be if the way the Supreme Court had decided to style this opinion was not Loper Bright Enterprises, but Relentless, which was the name of the other case. I mean, that'd be just so much more fun. But instead, it's not Loper Bright, it's Loper Bright Enterprises. That's what we're supposed to say. But in any event, in one of the lower court opinions there, the court, in fact, said, the statute might say the agency can do this, or it might be ambiguous. The lower court didn't even bother to make clear whether it was a step 1 or step 2 opinion. It was just the agency wins. That not only was the court concerned about whether or not that was faithful application of Chevron, but this other concern about short-circuiting text. I think if you look at the court's opinions over the last 10 years in particular, you look at trends in what's been occurring in the executive branch over the last 30 years, I think there's another concern that played into this, which is a concern that the way agencies were approaching statutes had changed as well. And that the old way, the way that the justices would like the agencies to approach statutes is, okay, we're an agency, we have no inherent powers. We only have that power and authority that Congress delegated to us, right? We look in our Constitution, there's no reference at the federal level, there's no reference to agencies. States are different. You don't have to. My kids make fun of me that I have one of these like every jacket pocket, but I do. So there's no mention of agencies. And so the kind of the old way is Congress gives agencies a task. There's a mischief Congress wants to address. And it says, well, one way we're going to address this is we're going to give power to an agency to address this mischief. And the agency should, as Article 2 tells the executive branch, faithfully execute that law to do what Congress said to do, the way Congress said you could do it to solve the problem Congress wanted solved. And for a whole bunch of reasons that we can get into, the trend increasingly over the last few decades has been less of that. And has been more, the executive branch has a policy position. And I want to stress this is not the current administration or its predecessor. This is a trend that's been building, going back at least to the 1990s, of the administration having something it wants to do, it having no desire to go to Congress or no confidence that Congress will cooperate. And so instead, the instruction to agencies is, this is what we want to do, go figure out how you can do it. And I would certainly argue that to a majority of the current court, that's not what agencies are supposed to do. That's not faithful execution. That pouring new wine out of old bottles is not what agencies are supposed to do. If you want new wine, you go to the vintner, which is Congress. And Chevron increasingly had been used. And so if you look at Loper Bright against the background of things like the major questions doctrine, which I think is also potentially important for securities law and certainly some of the things the SEC is doing these days, there's this underlying concern that's driving both of them, which is agencies, you're really only supposed to be doing the things Congress gave you to do. This is not a game of finding a statute that if you look at it in the right light or from the right angle, can give you the authority to do something Congress had not even contemplated 30, 40 years ago when they enacted that statute. This is about faithfully doing what the statute told you to do. So all of this background is in part of saying, there were ways the court could have addressed those concerns without overturning Chevron. There were opinions out there that provided a roadmap to that. One of my personal favorites is an opinion the Chief Justice had written in dissent in a case called City of Arlington versus FCC. But I think given the composition of the court, given the desire to have a six justice opinion, as opposed to some kind of splintered mess, you solve these problems by overturning Chevron and giving Justice Gorsuch the tombstone he really wanted. Okay, so let me, in the last couple of minutes, just say, okay, what does Loper Bright do? Because I said the important part is kind of what it does. And I think the best way to understand it is Loper Bright says to courts, get rid of deference. There is no obligation to follow what the agency said. There is no more a scenario in which you will ever be required to approve what you do not think is the best possible interpretation of the statute, which Chevron did require in some circumstances. But rather, you give respect to agencies. And that's really important because Loper Bright does not establish de novo review of all questions of statutory interpretation. It, in some respects, restates and in some respects updates something that we've sometimes referred to as Skidmore deference, but Skidmore deference isn't really deference. Skidmore deference is really about weight, about respect, about recognizing that the agency knows more about this than you do, has a history with this subject matter, has expertise in this subject matter, and you'd be a really bad judge if you didn't acknowledge that and pay attention to that because they deal with this every day and you deal with this once every hell of a month. Or years for some cases. But at the end of the day, the question you are still focused on is what does the statute say and what power did it give to the agency? And there are some parts of the opinion that are easy to overlook where the Chief Justice even emphasizes that this might mean that there are instances in which the meaning of the statute runs out. You get a word like source, it's not really clear what it should mean in a particular context. And that when you read the statute in its entirety and look at what Congress is doing, it's pretty clear that Congress delegated that discretionary policy choice to the agency. And if that's what Congress did, courts are obligated to follow that. And that's important because there are some, including some on the court, who would have preferred that Chevron be overturned on broad separation of powers grounds, right? This is about courts interpret the law, Congress enacts the law, agencies, you just implement and enforce, stay in your lane. That's not the opinion that Chief Justice wrote. it is devoid of much reliance on constitutional concerns. There's stuff about the nature of judicial power. There's stuff about what the job of courts is. We interpret the law. But at the end of the day, he rests the opinion on the Administrative Procedure Act tells us that we interpret provisions and we decide questions of law, not agencies. And so it doesn't mean that Congress can't still say to agencies, fill in the gaps, resolve ambiguities, deal with statutory silences and so on. It means the court has to really be convinced that that is in fact what Congress did. The agency's interpretation is not opportunistic, but is in fact faithfully executing what Congress wanted it to do. And as lastly, I was close. What that means, I think, in practice is, and I think we've seen this in the Supreme Court. We've seen this in the way the Solicitor General's office in particular has been defending agency actions over the last at least 5 years. The Supreme Court prior to Loper Bright had not relied upon Chevron to resolve a case in 6 years, not for lack of opportunity. And the Solicitor General understood that, and you can see case after case across a wider range of subject matter where instead of saying, okay, Your Honors, you approach this with Chevron, focusing a lot more on the traditional hard work of statutory interpretation, and understanding how the various tools of statutory interpretation help us understand what in fact the statute means, because that is the key in all of these areas now going forward, which means it's a good thing we spend a lot of time on statutory interpretation in our first year leg reg course, which I have to teach next semester. So, hey. All right, and with that, I will turn things over to
Right. Well, I mean, I knew when I agreed that this is a securities law conference, but this is kind of an admin law panel. And I knew when I was agreeing to be on an admin law panel with Jonathan Adler that I would be at best the B side on this. He's up here. He's barely got any notes. He's got his constitution. I was hoping I would at least be a good guy, be like Strawberry Fields to your Penny Lane. But I know now that was. Instead, I'm going to be, the one where they let Ringo do the lead vocals. I'll do my best here. I'm mostly a corporate law guy, of some securities law as well. And my task is to discuss a little bit the sort of impact, the significance of the end of Chevron for corporate law somewhat, and securities law mostly. And for corporate law, it's a bit tough in that Chevron doesn't really play that much of a role in corporate law, at least viewed narrowly as the internal rules of governance for corporations. That's primarily state law, not federal. It's primarily enabling in nature, rather than sort of based on administrative agency regulations. So none of that stuff ought to be all that much impacted by the demise of Chevron. Of course, more broadly, the legal environment in which businesses operate is heavily regulated, shaped to a tremendous degree by agency determinations and regulations. So corporations as businesses, particularly to the extent they operate in heavily regulated industries like finance, are undoubtedly going to be fairly impacted by the removal of Chevron deference. Significant effects from what relentless. I'm just going to call it relentless instead of Loper Bright. Let's do it. Under relentless, and its Ohio equivalent TWISM, and actually maybe I'll talk about TWISM a little bit as an initial matter, because actually it's a good example of the kind of dynamics that sort of used to go on with interpreting agency actions, and sort of how we might think about how courts are going to be looking at agency actions going forward. So let me talk about TWISM for a minute. And actually, first thing to note, another reason I feel inadequate on this panel is that TWISM actually came 2 years before Loper Bright Relentless, and both cites Jonathan Adler's work, and I'd say he claims anyway, heavily relies on his framework, right? For viewing these questions, and you might as well have just photocopied it for Loper Bright itself. So I believe I'm sitting next to the father of Loper Bright here. So TWISM anyway, about actually half of states had rejected Chevron deference prior to the Supreme Court actually acting in Loper Bright, and Ohio was one of them. And the winds of change here were felt first at the state level. And before TWISM, Ohio law was a little muddled, I guess, on how courts were to treat agency interpretations of statutes. I mean, the TWISM court itself, it's one of its section headings is Ohio has what did it say? Deference cases, but no deference doctrine, right? So there's a lot of cases where they're deferring to agency regulations, but no sort of through line, no paragraph tombstone that the law students could memorize as to exactly how they treated agency interpretations. And I think that's a pretty fair description of where things stood. I mean, for a long time after Chevron, Ohio courts rather unreflectively just deferred to agency interpretations, and then over the past 20 years or so started to sort of seem a little hesitant about it and suggest that agency interpretations are being deferred to because they're persuasive, not because we have to. But they finally sort of ripped the Band-Aid off with TWISM itself and held that a court is absolutely never required in Ohio to defer to an agency interpretation of a statute, even where the statute is ambiguous, even where the agency's interpretation is reasonable. There's no deference as deference owed to it. It may be persuasive, it may not be persuasive, but it's not something they have to defer to. And the actual dispute in TWISM, as I say, I think was illuminating in how this sort of might change the regulatory landscape. So TWISM, the company, not the case, TWISM, the company, was trying to get it's an engineering company, or it was wanting to enter the engineering industry anyway, wanted to offer engineering services. And under the statute, one of the requirements for getting a certificate allowing them to offer engineering services was that they needed to designate a specific person or persons who would have responsibility for the firm's engineering services. They'd be responsible for and in charge of the firm's engineering services, and that person needed to be full-time, right? And it said they need to be a full-time, I forget the exact language, but it was a full-time partner, manager, member, officer, director of the business, sort of listing out all of these things. So you've got to have a person, right? An actual human being who is a professionally registered engineer who is taking responsibility for the firm's engineering services. And TWISM, when it was applying for this certificate, it named a person who, in fact, was going to provide all of the engineering services provided by the company. But he's not an employee or a director or anything else. He's an independent contractor that's going to be providing all the services, not an employee receiving a W-2 or a director or owner or anything like that. And Ohio's board, the certification board, rejected the application and said you can't use an independent contractor as your responsible person designee, because the company lacks the power to control an independent contractor. It's the definition of an independent contractor. They don't have the power to control the manner and way he's going to be performing the engineering work, right? And when it got to in the lower court, I mean, there were a couple levels of review here. But one of the lower courts just said, well, we're under Chevron or whatever the Ohio equivalent of that is, right? We just are going to defer to the agency. It's ambiguous under the statute, so we defer to the agency. When it got to the Ohio Supreme Court, they went through the same sort of analysis that the Supreme Court ultimately went through, maybe a little more strident about sort of separation of powers slightly, but disposed of the idea that any at all is due to the agency interpretation. And I believe they did characterize it as a de novo review. in TWISM. I think they use the language de novo review, acknowledging, of course, that what the agency does is perhaps persuasive evidence. And they said, look, the statute doesn't say anything about the designee needing to be an employee or an owner, a partner or anything like that, or especially doesn't say anything explicitly about them not being able to be an independent contractor. It just says they need to be a manager and responsible for all of the services. They define full-time as responsible for all of the engineering services offered by the company, and this guy was going to be that, right? And so the court acknowledges, look, you could argue that the statute should require the designee to be an employee, right? With the idea being you want the firm to have control over the designated manager, but that kind of argument is a policy argument. There's nothing in the statute that actually says that, so it's best directed to the legislature is where the court came down. All the statute actually says is the designee needs to have responsibility, not that the company needs and control, not that the company needs to have control and responsibility over the designee. So overruled, TWISM gets their certificate, right? All right, so I think that's probably a pretty good sort of example of the way courts are going to deal with these kinds of things going forward, at least in states like Ohio, and I think probably at the Supreme Court level. And where does it leave us? I mean, I'm just going to try to provide. We've got panels that are going to talk about specific issues going forward, but in terms of the general dynamics, I mean, the concern, of course, the negative, the hit on Chevron is that it's going to increase sort of regulatory uncertainty. At least in the short term, right? That it's going to make it more likely that existing regulations are going to get challenged and that they're going to get overturned by courts. And this combines with the reside. See, I never remember Supreme Court cases because when I hear Supreme Court, my mind immediately fills in Delaware Supreme Court. What's the one where they say the statute of limitations doesn't start running? Corner post, right? The statute of limitations on challenging an agency regulation doesn't start running until the actual company plaintiff suffers an injury, right? So even long established regulations could be challenged, at least in theory. So the idea is everything's sort of up for grabs now with agency regulations, and that's going to make it harder to rely on agency guidance going forward where there isn't case law, right? And on the securities law side, right, there's an awful lot of pending or prospective SEC rules that are in some serious doubt as to whether they're really going to be able to survive sort of de novo-like review by the federal courts. I mean, Dean Rose mentioned a couple of them, right? Like the climate-related disclosures, enhanced climate-related disclosures. Those were already under fire as potentially sort of exceeding the SEC's mandate, and I think they're far less likely to survive without Chevron deference. Cryptocurrency regulations. We have Paul Graywall, who's the chief legal officer of Coinbase here. So I will modestly say he probably knows more about this than I do, right? But the SEC has been struggling to sort of shoehorn cryptocurrencies into the existing sort of body of regulation, and how do we apply the Howey test to determine whether these are securities or whether they're commodities or something else altogether, right? But post Chevron, any new rule or any enforcement action that they try to take against cryptocurrency related company could be contested on grounds that Congress never really gave explicitly the SEC power to regulate cryptocurrency. Or whether Congress, or in the proposed manner, right? However they end up doing it. Some people talk about SPAC regulations, that some of the things they've talked about doing with SPACs might run afoul of court review under Loper Bright. Frankly, I have a hard time thinking that matters that much, and that I don't think SPACs are coming back anytime soon. I think it's going to be a while before the market has an appetite for SPACs again, one way or the other. There's other things like the expansion of rules on who counts as a dealer and things like that I think are really up in the air now after Loper Bright. And given the vagaries of litigation, how long it can take to actually get a case that makes it all the way to decision, right? It might be a long time before we have any real confidence on how any of those are going to end up. On the other hand, right? So short term, and maybe short term means longer than we would like. We're maybe facing greater sort of regulatory uncertainty for businesses. I think longer term, at least, the optimistic view is that the demise of Chevron it could increase regulatory certainty in the long run, right? And that could be for a couple of reasons. First off, right, at least in theory, agencies won't have as much wiggle room to sort of expand their regulatory activities in unanticipated ways that you wouldn't be able to know is at least a possibility by looking at the statute, right? And particularly given the current judiciary, it certainly seems that if legislatures want an agency to have power to regulate a certain kind of activity, the legislature is going to have to be more specific in the statutes, and that's in the long run probably makes it easier for regulated businesses to know what rules are going to apply to them. Second, to the extent that the judiciary, at least to some degree, supplants administrative agencies as sort of the final word on statutory interpretation, we'll be swapping in somewhat more stable judicial case law and precedent for agency interpretations, which are, with the change of administrations, likely to sort of whipsaw back and forth. You can just think of the last 8 years going from the Obama administration to the Trump administration to the Biden administration to the, we'll see, administration going forward. Perhaps those swings will be a little less dramatic going forward, to the extent the judiciary is playing a larger role. And more generally, I think the demise of Chevron deference is going to make it a little harder for federal agencies to sort of put their oar in on traditional state law issues and issues that arguably go beyond their mandate. I'm thinking of things like the Department of Labor's ERISA fiduciary rules and rules on non-competes, use of non-competes, the FTC, things like that. And I mentioned SEC and climate change disclosures. All of those are kind of already on the rocks at this point, and I think I'm not confident any of those are going to survive in this post Chevron world. I was hoping to conclude with some sort of sweeping, bold prediction for some long-standing area of securities law that I think is going to be swept away by the tides of change here. I couldn't really think anything that plausible that I think is on the verge of death. To the extent, in the long term, anything might be vulnerable. Perhaps rules against insider trading, in that there's not a lot of statutory support for a great deal of what the SEC has done over the past few decades in terms of enforcement actions against insider trading. So in theory, the courts could act on that. And maybe also market manipulation. Market manipulation is not something that's clearly defined or defined at all in the securities laws. And it's mostly preceded by agency enforcement action, and that could be at some point. It's been around a long time, so it would be it's going to be a tough case for the courts in terms of deciding, are we really going to open up this can of worms? But it's at least possible post Chevron. I mean, the other thought I had is that to the extent getting rid of Chevron makes courts more important participants in the regulatory process, it might cause lobbying activity. I was talking about this at dinner last night. Lobbying activity to migrate at least somewhat away from administrative agencies and towards Congress, where legislatures, where it already is, but also perhaps courts a little bit more. And I'm not entirely sure what that would look like. But if I were running a business, I would want to hire ex-clerks, law professors that know a lot of judges, things like that, to help me think about how that would work. So, and maybe, yeah. No, I'm kidding about that, but but I do think it's going to increase the sort of political pressure on courts and lobbying pressure on courts going forward. All right, I'll stop there and leave time for you to ask Jonathan questions.
Calling folks, you guys calling folks?
Yeah, I do have microphones. If people have questions, would like to. Yes, sir, hang on one second here.
Yes, thank you. I know this is a security conference, but since Professor Adler's here, I have a question more environmental related. In your view, do you have a view as to whether the IRA is written clearly and unambiguously?
It's going to depend on the provisions. I will say a broader point, and this relates to what Congress does generally, right, is that insofar as Congress is using fiscal tools to achieve various policies, which the IRA mostly does, that's less important of a question because the ability to get judicial review of fiscal tools is just more difficult. And under current law, kind of the weapons at a litigant's disposal to deploy against an agency are fewer in the context of fiscal instruments. So so while there are some things there that may or may not be ambiguous and may or may not be being interpreted the best way possible, it's just much harder to get a litigation foothold there than when the agency is regulating, right? Because you need the final agency action, you need standing, you need a doctrine that gives you the opportunity to review what the agency's doing. If most of what the agency's doing is doling out money, that's really, really hard to do. And so it becomes a little less important. What I thought you were going to ask about the IRA, which relates to some other things, is there are some folks that like to argue that there is some language in the IRA that is relevant for other regulatory disputes. And I'm incredibly skeptical of that, because insofar as part of the message the court has been giving is we want Congress to speak clearly, Congress kind of fainting or gesturing at something isn't going to cut it. And so in a context like the SEC, insofar as the SEC is dealing with things that were not remotely in anybody's imagination the last time Congress reformed securities laws, crypto might be an example of that, right? It's going to take more than some interesting language about Congress's purposes, whatever, in a statute that's doing something else, or in a funding bill to reinforce the agency's authority. That if insofar as there really is uncertainty about the agency having authority, the message of the other cases in this space the court has been issuing is, our assumption is the lack of clarity about delegating authority is a failure to delegate authority. Our constitutional baseline is that agencies only have the authority Congress gave them. And so if we're asking the question, that's a pretty good indication the power wasn't given. And that's going to require Congress to be more explicit. And I think whether we're talking about climate, which the IRA relates to, although there are also gets provisions relating to pharmaceuticals, which may have also been your question there, where there's lots of litigation. But also areas of securities law, whatever, Congress is going to have to be explicit if we're not sure that the agency has the power to play in that space. It's going to be less of an issue where we're focused on details about how the agency gets to play in the space. I mean, I read Loper Bright in conjunction with other opinions, especially the chief has written, as to really be concerned about that first question. What power did the agency get in the first place? And there is this kind of, we don't let foxes guard hen houses sort of notion that if we're trying to figure out what power the agency has, it's not clear why we should ask the agency. Yeah, that's the agency. Right? I mean, the agency is going to have a self-serving answer. And so while it may make sense to try and help, if the agency has authority both to regulate things that act like commodities and things like that, like securities, if the agency wants to say, well, we want to put this one thing in one bucket versus the other, but the agency has authority either way, well, that might be something that we might defer to the agency in terms of giving it respect. But if the question is this something that is regulable versus not regulable at all? that's the sort of question that agencies have necessarily have a self-interested answer to, and so we're not gonna defer. That's probably a much longer answer than you wanted, but. Wait a minute.
So I really enjoyed this. Lucky to have you both as colleagues, especially if I need a copy of the Constitution. I'll stop by later. So yeah, despite the fact that I appreciate the relentless discussion of Loper Bright, and see what I did there, I do wonder whether or not it matters in the area of securities law. And the reason for that is, I have a paper on this in the Seattle Law Review, and David Zaring has a piece that's coming out as well. You know, if you look at the opinions from the Roberts Court, it's cited 3 times. A majority opinion where it basically was forced by what the lower court did, a dissent and then a concurrence. You know, as a result of that, you know, it seems like everything was being forced into textual analysis already. Meaning there's very little mention of things like legislative history in regard to the Roberts Court's opinions on securities law, and there are a lot of them, 2 per term, which is a major portion of the docket. You know, I'm wondering, you know, in terms of thinking about this, and I know Charlie got into this a bit, in terms of what the lower courts actually were doing, you know, does this matter? And in terms of what they're going to be doing in regard to securities law, does it really change anything? I mean, is it more of a Pyrrhic victory? Is it more of just a facial victory for people who are concerned about separation of powers? Or is it something that's really going to change how things are litigated in the lower courts? Because I don't know that it changes anything on the federal level.
Yeah, Jonathan will correct me after I say this, but I think you probably have a good point at the Supreme Court level. I think at the lower court level, though, I suspect it's going to make more of a difference in that, you know, obviously only a very small sliver of cases are going to make it all the way to the Supreme Court where they're going to get that kind of scrutiny, and a far greater percentage are probably never getting there because they're decided on either Chevron deference or something approaching Chevron deference below.
So, I agree with that. Let me add a couple little wrinkles, right? So one is, an added reason in support of it might not make much difference in a lot of areas we care about securities law as well, is there is this paragraph in the opinion, which oversimplifies a lot, which says, prior decisions that relied upon Chevron are entitled to statutory stare decisis insofar as they allowed an agency action, right? So insofar as, and we could have a very long discussion about how you actually unpack that. There's actually a case from the Sixth Circuit from just a couple weeks ago where the judges are going back and forth about, like, what does it actually mean? Because if the prior decision said that the statute was ambiguous and so the agency got to do X, and at a later time the agency did Y, and we said it was allowed to do that too, well then, what is it that we're giving stare decisis to if the idea that it's ambiguous and the agency then therefore gets to go back and forth is the one thing that's supposed to be off the table? So there's a lot of complexity there. But say for someone like insider trading, I'm more skeptical that that's going to be on the table, because I think that the decisions that say the SEC can enforce this with this authority are going to be entitled to statutory stare decisis, and there are really only 2.5 justices that don't think statutory stare decisis is very important. But I think it affects a lot going forward, right? And so if Congress is legislating less, which it is, if Congress is not reauthorizing statutes on the routine basis that it used to, that means that there's a lot more action on the question of, can the agency do this new thing, right? So whether you're talking climate disclosure, you're talking crypto, there are a whole bunch of things where the agency's using an old statute and trying to use it in a new way. And, you know, we could argue, is it Loper Bright that's doing the work here? Is it West Virginia versus EPA that's doing the work here? Is it FDA versus Brown Williamson? Is it, I mean, pick your poison, right? Because all of these cases are pushing in the same direction, which is saying we're really suspicious of agencies coming along and saying, oh, hey, you never knew we had this authority, but we do, and now we're exercising it. And, you know, so, and I think agencies are responding, right? Why does the SEC final climate disclosure rule, why is it far less ambitious than the original proposal, right? Because at some point, the lawyers said, even before local rate, hold on here, we're not gonna win if we swing for the fences. Not clear the current rule's gonna win. And if it fails, you know, is it local right? Again, is it the major questions cases? You know, it's not clear which case you want to attribute that to, but the broader trend is if the SEC is going to do things in the 21st century that weren't thought of in the 20th century when it's the relevant statutes were enacted, Congress is going to have to get in that game. And that I think is important and significant. And local right does reinforce.
So thank you so much. It's amazing, but I'm biased. I'm also your colleague, so thank you for doing this. So I have a question. It's a two-part question and it relates to one another. And one is, you know, there is this concern and this notion of agencies that their wings are being cut, right? And then that's happening. And there's also this pressure from the corporate sector to bring in more litigation and try to push some of those questions. What can agencies do and not do? And I wonder if a little bit on your take, what do you think is the next litigation we're going to see? But there's a few that's already currently happening that I know people are discussing. And relating to that, we know that Congress should act, not sure if they're going to act. But that also relates to this before an election. What do you think whoever the different candidate is, how is Congress going to react depending on whoever gets picked? Thank you.
I mean, the short answer is I think the court's view would be if Congress wanted agencies to fly, it would have given them wings. And if it didn't, that's not our fault. They don't get to fly on their own. Right, who's the in Greek myths, the guy that tries to fly close to this one? Icarus. Icarus, there we go. And you know, I mean, there's that, I mean, I think that's part of the dynamic. In terms of the election, I think it is worth noting, right, that the Trump administration went out of its way not to rely on Chevron in defending agency actions, largely for ideological reasons, right? That the Trump administration had decided that in the right case, it would ask the court to overturn Chevron, and so it wasn't going to rely upon Chevron in defending rules, even in contexts where, you know, it was pretty clear that the only way an agency could win was with Chevron. And then the Biden administration hasn't relied on Chevron in the Supreme Court, not for ideological reasons, but just out of strategic reasons. When Solicitor General Elizabeth Freelager was here a couple months ago, I mean, she talked a little bit about, you know, how just it really changes the way you write briefs. And so I'm not sure the election is going to, the way agencies approach litigation risk, I don't think will change very much. I think the attorneys at agencies that are litigated against the law have gotten the message, and that really needs to write a different sort of brief. Whether it affects what they try and do, who knows, and whether Congress gives them more instructions, you know.
I don't really have anything to add to that other than, I mean, it is really incumbent upon Congress to, you know, if you've got a hot button issue that you want an agency to be able to regulate, gotta give them their wings. I don't know whether the institutional dysfunction will be so great that will cause problems, but if anything, it just builds pressure to resolve those dysfunctions.
I could actually one little point just on the clipping of the wings thing. Yeah, if we want to think about what lower courts are going to do, right? On the one hand, we care a lot about what the opinion says and parsing the language, and you know, Chief Justice Roberts in particular is a very careful opinion writer, and when something's unclear, that's deliberate. When it's clear, it's and so on. But there's also the mood, right? And the Loper Bright does not. Loper Bright Enterprises was not the only administrative law case of this past term. It's not the only important administrative law case of the past 5 years. And there is a theme, right? When you start to put together with Jarkissi and Corner Post and Biden versus Nebraska and West Virginia versus EPA and so on. And there's certainly a broader theme to lower courts, which is you've been too permissive to agencies, period. And whatever doctrinal box you're evaluating agency action in, there is a very clear message that agencies need to be put through their paces. in a broad range of contexts. And so even apart from what any individual case says, I think you will see lower courts doing more of that. And we've seen that in some areas. So one area that we see this already, for example, it deals with the so-called shadow docket. You've heard all about the motions docket the court deals with. And the court, somewhat unusually in the last decade, has stayed some major environmental rules. It's pushed pause on some environmental rules pending litigation as a way of deferring enforcement deadlines, which for some types of firms, utilities in particular, enforcement deadlines need to be much farther out in the future if they're not going to pinch prior to litigation. And we've seen in the DC Circuit, and we've seen at the agency level, paying a lot more attention to, there being a lot more attention to the various factors and making sure that the agency has thought about these things and so on. And there's no written, because these are a lot of shadow dockets, no written opinion about stays that really said, oh yeah, lower courts, you really need to do this more. But we see in these unpublished orders the DC Circuit's been putting out, adding an extra paragraph. Yes, we actually did think about this. We actually really did consider the stay request. And so I think this broader mood is having an effect on lower courts, and I think we should expect that to continue.
Let me just make one broader point too. I think there's a lot of sort of first order thinking that Chevron and some of these, Loper Bright and some of these other admin law cases are going to lead to sort of a less intrusive regulatory regime. I'm not sure in the long run that's true, and that if you allow a legislature to dodge its responsibilities by letting agencies have a little more leeway, right? They'll do some of the things that maybe the legislature would do, but they'll have to do it fairly cautiously and in a limited fashion. They'll be constrained to some extent. Like Congress isn't constrained in the same way, and if you force them to actually act on the priorities they want to give the agencies power on, they might act in far more sweeping ways than the agency would act on their own. And I think we see this with respect to other hot button issues that I won't talk about here. But when you actually force an issue back onto the legislature, it can result in sort of different policies than you might have expected at the end of the day. And I think we'll see that here too.
Thank you. This has been terrific. I'm curious if you see any real impact from Loper Bright on enforcement or in the context of enforcement actions. If not, do you think this will also likely push more policy being made in the context of enforcement and active litigation as opposed to rulemaking?
I mean, it depends on the nature of the enforcement action, right? If the action is an area where it's well-trodden ground, then it's not going to have much effect. But if the enforcement action is being used as a way of changing policy, expanding policy, presumably that's dependent upon the agency, making some claim about what the statute means that may not have been relied upon before. I mean, there's a lot in Loper Bright itself and in Skidmore, which the opinion tells us we should look back to, which emphasizes we care a lot about consistency of agency interpretation. We care a lot more about an agency interpretation that was announced at the time a statute was enacted than we do about something that occurred 10 or 20 years later. And there's a whole bunch of reasons for that. One of the easy ones being agencies were often at the table when the statute was written. And so when the week the statute comes out, they issue their guidance document saying, oh yeah, and here's how we're interpreting it. We think that's more than just the agency's policy preferences speaking. But if 20 years later in an enforcement action, the agency says, we haven't had to do this before, but we've now decided this new thing that you're doing, we think is covered by this statute, but we've never had to say that before. Right? A message of Loper Bright, the antenna should be up. Now, it doesn't necessarily mean the agency loses. But when you put it together with what we've seen in the major question doctrine cases, insofar as the reason we haven't seen it before was it's something that is new, that's an extra reason for the agency to be cautious, right? Because it's not, people hadn't done this before, but we always knew this was possible. And when someone finally tries it, the agency takes an enforcement action, and so the agency's on strong ground. If it's truly new and truly different, well, then even if the language could be interpreted this way, the court's giving us lots of reasons to be skeptical that that's really the best meaning of the statute, because the mischief the statute was enacted to combat was this thing that was occurring in the 1980s, not this thing that's occurring in the 2020s. So I think in those sorts of contexts, it could matter a lot. And then, of course, there are all sorts of questions about, dealing with the risk of being wrong in the context of enforcement action. I mean, and so it certainly, in those cases, can affect the leverage the agency has. Presumably when you're defending against an agency enforcement action, one of the things you think about is, if I fight this, is the agency, what's the likelihood the agency prevails? And there are contexts where that's going to shift.
I think you've seen the SEC change enforcement positions as a result of these recent opinions in the past year. Definitely jerkacy and going to court rather than ALJ, and in the crypto space, they have retracted, or with some defendants in some cases. I'm sure those cases are impactful, but I want to end on the dysfunction piece because the markets need certainty, right? And so if the SEC can't develop policy on crypto, because obviously it was never contemplated 100 years ago, and we have Congress who's incapable of passing legislation, then the markets and firms like Paul's, what are they to do, right? So that's the problem that I see, is that we have these innovative and emerging technologies and markets that need certainty, real dollar stakes for investors and for companies in our country. And Congress, this is not new, it's been a decade, and we do not have regulation that is, well, we'll discuss this later, but some would say we don't have clear regulation. We certainly have a lot of enforcement, and we have no legislation.
Two quick things. One, a point that Charlie made earlier, which I think is really important, is that in the long run, judicial opinions are more stable than agency opinions. It's very clear that another thing that the court was concerned about, and Justice Gorsuch has spoken about this a lot, and he saw this as a judge on the 10th Circuit in the context of immigration cases, which are just the sort of agency cases he would get a lot of in the 10th Circuit, is that a lot of uncertainty is caused by the fact that agencies can change their minds, and they can be opportunistic about it, and they can be political about it, and they can be doing it every 4 years, right? Whereas courts, especially when it comes to statutory interpretation, don't do that, right? Whatever stare decisis weight constitutional decisions get, statutory decisions get a lot more, and that's not going to change anytime soon. So once you get judicial resolution, you get some degree of certainty, and I think that's important to keep in mind, that's you're kind of a short run, long run in terms of uncertainty in that regard. Because if agencies can change their minds, then how much certainty do you have every time there's a new election? And so that I think that's true. But certainly, Congress will need to act more, and if it doesn't, that's a problem.
All right, gentlemen, thank you so much. That's obviously